not been able to take anything down.
Gotcha.
So sorry about that. Good morning, ladies and gentlemen. My name is Judge Lal, and we're going to proceed with our misdemeanor ORCA calendar. If you folks will please hold on the Zoom format. Miss Carter, we're about to take a plea in position number 2, case
Okay.
number.
I'm ready, Judge. Thank you.
All right, 21 CR 005-445B, State versus Ilobueke Shineke, is that correct? Okay. And so representing the state is Miss Angela Waldrop, and counsel is present with his client. Mr. Shineke, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Murphy will be representing you. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
All right. From the various charges, the state has decided to move forward with 1 count of reckless driving and 1 count of striking an unattended vehicle. The failure to maintain lane will merge with the reckless driving. And Ms. Waldrop, I apologize. What were the terms for the plea again?
No problem, Judge. So on that reckless driving, it is 11 months and 29 days. Credit for time served 1 day with the balance on probation, to pay a $300 fine, complete 40 hours of community service, risk reduction, and alcohol and drug evaluation, and any treatment deemed necessary, as well as a victim impact panel. On the striking unattended vehicle, we agreed to a $200 fine. Counsel, do you stipulate to a factual basis, venue, and identification for purposes of the plea?
Yes, for the purposes of this plea.
And Judge, we did agree that it could terminate upon successful completion of all conditions. Nothing further.
All right. Mr. Shineke, have you consumed any medicine or alcohol recently? You need to say yes or no so the court reporter can hear you.
No,
All right. And have you understood the proceedings in your case so far?
I do.
Are you satisfied with the legal services you've received?
I am.
And is anyone forcing you or inducing you to accept this plea offer today?
No,
If you decide to plead guilty to the charges of reckless driving and striking an unattended vehicle, you would have to give up your constitutional rights to a trial before a judge or a jury. You will not have the opportunity to have your attorney with you in a court of law, to challenge the evidence brought against you, to confront your accuser, present any defenses or arguments you may choose to do so, or have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
I am.
All right. And has your attorney explained to you that pleading guilty to these charges can incur points on your driving history?
He has.
All right. And it may have effect upon other issues such as your professional licenses, your residency, or anything to that effect?
I do.
So I understand that we are pleading to probation of 11 months, 29 days for that purpose.
That's correct, Your Honor. Thank
All
you.
right. Mr. Shineke, how do you plead to 1 count of reckless driving and 1 count of striking an unattended vehicle?
I do. Guilty. Guilty, sorry. It's okay.
I mean, you're not getting married today. You're just pleading to a couple of misdemeanors. Okay. With regards to your sentence on reckless driving, is going to be 11 months and 29 days with a credit of 1 day in jail, and which will leave you with a remainder of 11 months, 28 days to be served on probation. You will report to probation next Tuesday before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta, that site, all right? While you're on probation, you will pay a $300 fine, complete 40 hours of voluntary community service at any nonprofit agency, complete a risk reduction program, undergo an alcohol and drug evaluation within 30 days from today, and attend and complete 1 victim impact panel. With regards to striking an unattended vehicle, that's an additional $200 fine. If you complete all your fines, you completed all the conditions and programs, and you're not required to submit yourself to any treatment from the evaluation, your probation will terminate upon completion. Did you have a question about probation?
I do, Judge. Dr. Shineke is a medical physician in the state of Wyoming.
We spoke with Ms. Waldrop earlier. We were going to ask the court if he could report by phone or mail.
All right,
his
I'll
distance.
allow, is he still gonna be here till next week?
I leave on Sunday.
He leaves on
Sunday, okay. Do I have anyone on probation? No, I don't have anyone on probation. I'll allow telephonic reporting. Normally, your first visit has to be in person. Would you be able to extend your stay till Monday?
Unfortunately, I have to be back to work on Monday.
Okay. All right, counsel, you just have to make sure that when you contact probation, you let them know the judge has authorized telephonic reporting.
Okay.
And then, we'll need all his contact information that you can convey to probation.
Think we
Unfortunately, I
submitted-
don't have anyone from probation with me today, so
Okay.
otherwise they could. The only thing we do is have your client fill out the probation form, which I've done, assume we've done.
We've
All
completed
right.
that, yes, Your Honor.
And just make sure we have a good number and they have a good number, give your case number
Okay,
and take it from there. The 40 hours of community service can be done at any nonprofit agency designated a 501c, but you cannot do it at a church or a school. All right,
Thank you.
any questions?
Not at all.
All right, best of luck. Thank you.
thank you,
Thank you.
Judge.
Okay, I don't think I have any council or parties or other individuals on Zoom, so I'm just going to proceed with the cases in the courtroom. Ladies and gentlemen, as you know, this is the ORCA misdemeanor calendar with the State Court of Fulton County. This is going to be the motions calendar. I'm going to be calling the status of the remainder of cases, and we're going to see how we're going to proceed this morning. Leonard P. Bennett Jr. Good morning.
Good morning.
Miss
Your Honor.
McC-
Good morning,
yes.
Ms. Howard here from Stanton.
All right. And what are we doing?
Good morning, Your Honor. Steve Rosenberg on behalf of the state.
Okay. Well, that's a new name I have to add to my dossier of prosecutors. Good
Yeah.
morning, Mr. Dossier. Yes, sir.
Morning.
And how are we proceeding?
I think we're ready to argue the motion for new trial.
Okay, thank you. If you all like to come forward. Position 2 has been a plea. Position 3, Michael Honeycutt. All right, sir. Okay, as soon as you're done, you and your client can have a seat at the front bench seat right here, as soon as you're done with the paperwork. Jared Houston,
Morning, Judge.
morning.
Mr. Haas here, Mr. Houston, he is on his way, he's in traffic, he's called several times.
I totally understand. Oh, okay.
There's one aspect of it we are hoping to discuss with your honor about what time he will or will not get credit for. He's otherwise ready for a plea. If he needs to go into custody today,
Okay.
we have to reset it. But we would like to discuss that issue with the court. I think the state will refer to your honor on that decision for.
All right, counsel, if you'd like, we can, if you want to waive his presence with regards to time.
Sure.
Okay, you can have a seat right there and then we'll take your case up next.
Thank you.
And then position 5, Paul Jones, we've reset that case to June 7th at 1:30 p.m. Position 6, Jarrett Meyer, the case is reset to July 19th at 1:30 p.m. for motions calendar. And the Jones case is reset to the final plea calendar. Oh, all right. Yeah. Mr. Josmick, you and your client already, or please have a seat there. Okay, who has got the, is it Houston or Houston?
Houston.
Houston, all right. I thought it was only unique to the county, but I
No.
guess, all right, okay. Miss, I'm sorry, give your last name again. Abasi, that's right. Leah, right?
Yes.
Okay, I remember the first name. Okay, sorry about that. Okay. Ms. Abasi, and who is the prosecutor? Mr. Jan? Okay. Yes, what is the recommended plea offer for Mr. Houston?
Yes, Your Honor, this is Mr. Houston's second DUI in 5 years,
Mhm.
in a 5-year time period. The date of this arrest was October 14, 2019. And he also had a June 15, 2019 DUI in Coweta County, Georgia. And so due to that, there is a minimum, custody sentence for 72 hours based upon the law.
Mhm.
And then it would just be all of the other DUI conditions, 12 months probation, alcohol, drug evaluation and treatment, risk reduction course, victim impact panel. There'll be a
Which of these charges are you proceeding with?
Just the DUI per se.
Per se? Okay.
Yes, Your Honor.
The others are going to be null prost?
I would ask the court to merge them.
Merge them? Okay,
Yes.
okay. All right, and Ms. Bossy, what is your, oh, if you'd like to take the podium so that the reporter can, Ms. Carter, this is position 4 on our calendar, State versus Jared Ansley Houston. His presence is waived at the present, currently. Yes,
Yes, Your Honor. So Mr. Houston had this case. He did provide the accurate address. At some point, notice was sent to the completely wrong address. We
oh, I
don't,
thought we were discussing the time that he wants to serve.
yep, getting there.
Okay,
The notice was sent to a completely incorrect address, so a bench warrant was issued. He had a warrant in another county in Coweta. They called and said, you have a warrant, please come and turn yourself in. Oh, and by the way, you have this Fulton County warrant for a failure to appear. So he went to Coweta County. He was there for several months. He did not file a bond motion right away because of the hold out of Fulton County. He was arrested February 14th, 2023. I became involved with the case, and at the end of March 2023, we were able to get the warrant set aside because again, it had been sent to the completely wrong address. So we were hoping he could get credit for that time while in Coweta County. I understand it was kind of on both cases, but
what was he in Coweta County in jail for?
he had a rape charge there.
Okay,
He had his preliminary hearing, and after he had a bond hearing, and he bonded out on that.
all right. But when did he post bond?
He posted bond in June. I would have to look at the date. I believe it was June 5th of 2023. His hold was lifted from Fulton County on March 25th.
All right. As soon as your client is here, we'll address that question. All right?
Thank you,
Yes,
Your Honor.
Thank you.
Your Honor, is there paperwork he needs to fill out when he arrives for the plea?
Yeah, if the plea is acceptable, then it's either going to be a non-negotiated plea where you're going to be arguing the time, or it's going to be a negotiated plea if you all agree to the time. But you can fill out the paperwork while you're waiting.
Okay.
And then if I don't give the time, he still has the right to retract the proposed plea and go for trial.
We'd not be asking to retract the proposed plea. We'd just be asking for a date to turn himself in, so he doesn't have to do it today.
Okay,
We will be going
All right.
forward with the plea.
so do you want to give her the paperwork, or normally they send it by DocuSign unless you've got hard copies
Do you
today?
have your computer here with you in court?
No, I do not.
Okay, I'll do the hard copy for you.
Perfect.
All right, thank you.
Thank you.
Bossy. All right, and Mr. Jarsmik,
Morning.
good morning, sir. Good, nice to see you without the screen. Okay, normally it's always Zoom with you. Okay,
I'm here in person sometimes.
are you?
Yes.
Okay, I'm getting old, so I forget. All right, Ms. Carter, we're addressing position number 3. This is State versus Michael Honeycutt. Case number 21 CR 005 723J. And this is going to be a negotiated plea?
That's correct, Your Honor.
All right. And counsel for this case, for the state is Ms. Waldrop, and Mr. Jarsmik, counsel for Mr. Honeycutt. Mr. Honeycutt, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and Mr. Jarsmik is going to be your counsel. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am.
Thank you. All right, Ms. Waldrop?
Thank you, Judge. Mr. Honeycutt is pleading to 1 count of reckless driving.
I need your microphone.
Oh,
1 count of reckless driving and 1 count of failure to report an accident. The wrong way on a one-way street is going to merge into the reckless driving. And the negotiated sentence on the other 2 counts for reckless driving is 12 months. Credit for time served of 1 day with the balance on probation, to pay a $750 fine, complete 40 hours of community service, risk reduction, and alcohol and drug evaluation and any treatment deemed necessary, as well as a victim impact panel, and provide proof of insurance claims that were settled in regards to this accident. Your Honor, defense counsel did provide to me documentation for the insurance claim that had been paid out, so that is
Okay.
complete.
All right.
He also provided documentation of the risk reduction course that has been completed, a certificate for that, so that condition is satisfied. He has provided an alcohol and drug evaluation. The treatment that was recommended was risk reduction, so that condition has been satisfied. And Mr. Honeycutt has completed a victim impact panel as well, so that condition has been satisfied, and I do have documentation of that. So I believe he only has the fine and community service to complete, and I believe he may have done some community service already. With respect to the failure to report an accident, it's 12 months probation to run concurrent. And then we did agree on termination after successful completion of all conditions. Counsel, do you stipulate to a factual basis, venue, and identification for purposes of the plea?
We do.
Nothing further from the state judge.
Thank you. Mr. Honeycutt, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing or inducing you to take a plea today?
No, ma'am.
And you understand that if you plead guilty to these charges, it will add points to your driving history?
Yes, ma'am.
All right. Has your attorney explained to you that if you enter such a plea, you would have to give up your constitutional right to a trial in front of a judge or a jury?
Yes,
You
ma'am.
will not have the opportunity to go back to court, confront your accuser, challenge the evidence brought against you, present any evidence, mitigating factors and arguments with the assistance of your counsel, and have the state carry its burden to prove the charges against you beyond a reasonable doubt.
Yes, ma'am.
How do you plead to one count of reckless driving and failure to report or return to the scene of an accident?
Guilty.
On the reckless driving is 12 months, credit for 1 day. The remainder of the time will be on probation. As you have completed the risk reduction, the alcohol and drug evaluation, the victim impact panel, and shown the necessary proof of resolution of any outstanding claims, the only other item remaining is the 40 hours of community service. If you have completed some hours, you need to show proof of that to your probation officer. Otherwise, you report to probation next Tuesday before 3 p.m. at 132 Mitchell Street, where the remainder of your conditions is to pay the $750 fine plus court costs and your probation fees, and to continue to complete your community service. With regards to the failure to report to the scene of accident, how do you plead? Did you say guilty already?
He did, Your.
Yeah, all right. So it's going to be 12 months credit for time served, balance probated. So that's just a probation matter. So if you complete the fines, the surcharges, the probation fees, and the remainder of your 40 hours community service, your probation will terminate. Is that correct, Mr. Jasmine?
That's correct, Your Honor. And I believe the state will tender a null pros on the DUI count.
Yes, it should be a null pros on the DUI, and the driving on the wrong way will merge with the reckless driving. So that should take care of the other two charges.
Yes, Your Honor.
Yeah, okay,
And Judge, I'll amend the hit and run to the failure to report.
okay. That concludes this case. Thank you very much.
Thank you, Your Honor.
Did y'all fill out the probation form?
Not yet. And
All right.
Your Honor, I will say that from this case was 5 years ago, and my client, from what I saw in the video to now, is a completely changed person. He's married now. His wife's here in support of him. He has a family and a good job. So he's come a long way in the last 5 years.
Well, congratulations. And she's going to keep you instead. So you have no way out from this point onwards. Thank you. All right, congratulations. Have a good weekend. Thank you. Yeah. All right. Ms. Abbasi, let me know when your client is present, okay?
Will, Your Honor.
Thank you. All right, this is State versus Leonard Bennett, middle initial P, suffix junior. And kind of representing Mr. Bennett, who is present in court, is Ms. Maureen McLeod. And Mr. Bennett, please remember you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. And representing the state is Mr. Rosenberg. Let me just pull up the case. This is a matter in which a bench trial was conducted before me, and a guilty verdict was rendered, from which after the defendant has filed a motion for a new trial. All right, Ms. McLeod, are you ready to proceed?
Yes, Your Honor.
All right, you may take the podium so that the court reporter may address that.
Your Honor, my client is seeking a new trial because he believes that the trial that he received did not truly present the facts of his case sufficiently, which would have, if it had been presented sufficiently, resulted in an acquittal. That happens to be his opinion. And this opinion is based on a number of things. First of all, he believes that he was not adequately instructed as to his right to a jury trial as opposed to a bench trial. That is one thing. He did not understand the possible ramifications of a bench trial as opposed to a jury trial. That's one thing. The other
Judge,
thing.
if I might, Your Honor, I don't want to object, but I'm going to object. I don't think I want to make sure just we're operating on the same sheet of music. I saw that there was a motion for new trial filed. I have not seen an amended motion for new trial where something like this might be alleged, right? And the state would be on notice of that. The motion for new trial that I have really asserts general grounds.
I understand, sir, but she's just doing her opening right now.
Okay, that's fine.
Yes.
Okay, thank you.
Yes, he believes that there are a number of factors. That is one of them. He did not fully understand the difference between a bench trial and a jury trial and why he should select one or the other. And he believes that had he fully understood that, he would have opted for a jury trial. The other thing is that he believes that there were witnesses that should have been called and they were not called. No witnesses were called in this case. In fact, the defense did not put up any witnesses at all, not even Mr. Bennett himself, to refute the state's case against him. And he believes that there were several witnesses who could have provided relevant evidence, which may have resulted in a different verdict. In short, he's alleging that his counsel was not as effective as he possibly could have been.
All right. And if I recall, his counsel was
Mr. Gaither, Your Honor.
Mr. Gaither, Frank Gaither, that's right.
Yes, yes, Your Honor.
And Mr. Gaither presently is no longer working with the Public Defender's Office. I understand he's moved on to another occupation.
I don't know. I don't know.
No, I'm just trying to get a lay of the land. Would that be correct, Mr. Rosenberg?
Judge, I don't know.
You don't know? Okay. Do I have any PDs over here? No? Well, that's the general information that I received. So, all right. Anything else, Ms. McLeod?
Yes, Your Honor, he believes that there was evidence which was allowed. There was testimony or evidence presented which was improper and should not have been allowed. Specifically, there was evidence regarding other incidents other than this particular date on which this incident is alleged to have happened that was allowed into evidence, which should not have been allowed into evidence.
All right. And has your client obtained the transcript of the
Yes.
bench trial? Okay, so they'll be able to point out to the areas where the evidence should have been excluded?
Yes, Your Honor.
All right, Mr. Rosenberg, do you have an opening?
Judge, well, again, the notice problem, because as I understand it, it's just filed on general grounds. I would just say, I hope again, we're all on the same sheet of music. I reviewed the transcript. The defense, he testified and he presented a witness as well. So I'm just, and I'll argue that, I suppose, when we're making argument, but I just want to, I hope I have the right trial, Judge, I guess is what I'm saying.
I was there, so I
Right.
guess I need to be it needs to be pointed out to me, these alleged deficiencies.
Sure.
All right, Ms. McLeod, who is going to be your first witness or on your motion for a new trial?
My client, Your
All
Honor.
right, Mr. Butler, if you'd like to have a seat in this particular location. Deputy, could we move the chair, please, away? And we need to remove that folder. Ms. Patrona, we have, Ms. James, we have that folder there. I don't know whose file that is. Thank you. Yes. Keep there. And the marshal is going to place you under oath. Oh, sorry.
Thanks, for the record. Leonard Perry Bennett Jr. Thanks. You swear affirm testimony that you're about to give in this court proceeding is true, the whole truth, and nothing but the truth to help you? Yes, sir. He's been sworn in.
Thank you, sir. Have a seat, sir.
Thank you, ma'am.
All right.
Can I sit?
If you may be seated, just make sure the microphone is close to you because our court reporter is on Zoom.
I'll go to the podium. Mr. Bennett,
Yes, ma'am.
at the time of your trial, well, before your trial, did your counsel instruct you of the ramifications of having a bench trial as opposed to a jury trial?
He just said that they'd offered to do a bench trial, and he was my attorney, so I did that.
He told you that the state had offered a bench trial option.
He said they'd offered a bench trial, so I went with what he recommended.
Okay. At the time, did he explain to you that with a bench trial, the decision would be made solely by the judge as opposed to 6 jurors in the jury trial?
He did mention that.
Okay, he did. Did you understand that the likelihood of just one opinion as opposed to did he explain that to you, 6 people as opposed to 1 person? Did you discuss that?
No, ma'am.
Okay. Did you tell Mr. Gaither about the witnesses that you felt would be helpful to your case?
I did.
What witnesses specifically did you tell him you would like to call?
I told him I would like to call, I would like to say, it's not an answer to your question. I'd like to say that I love Miss Baker and I didn't want to do anything to harm her. But the thing is that her aunt was one witness who knows her very well. She's lived with her in the past. And on an occasion, Miss Baker called the SWAT team on her own aunt when she was.
Okay, that's not responsive to the question. Mr. Butler, listen to your attorney's question and answer the question without going into a narrative. All right?
I was asking, what witnesses did you feel would be helpful to your case? And you can tell me them one at a time. So you said her aunt. What is her aunt's name?
I just want to object for the record, if I can just put it on the record. Again, there's just been a form motion for new trial on general grounds, right? Which the court can consider as a 13th juror. Generally, what is typical is once the transcript is prepared, someone will amend that to put the state on notice of what they're going to complain about, right? So that I might actually subpoena Mr. Gaither to be here to rebut what happened or get the transcripts from perhaps the arraignment where he was advised of all of his rights and, and then waived them. Unfortunately, as we're here and this is being raised this morning for the first time, I don't have the opportunity to do that. So I'm going to object on that basis.
So just to fine tune your objection
Sure.
on that, on May 20-something of 2023, Mr. Gaither filed a motion for a new trial. Yep, that's the one. And the issue was the verdict is contrary to the evidence and there's no evidence to support it. The verdict is decided and strongly against the weight of the evidence and contrary to the laws and principles of justice. And request the right to amend this motion upon production of the transcript. A amended motion was filed on December 28th, 2023. And I believe Mr. Gaither already, if I'm not mistaken, yeah, Mr. Gaither has already left the public defender's office. And this was filed by his current attorney, Ms. McLeod.
Judge, I don't think I ever saw that, and I
On
apologize.
December 28th,
I saw, on December 28th, I saw a
motion for
modify
modification.
the-
Oh, okay.
Right, it was
Modify
not
the
a motion
sentence.
to amend, Your Honor.
Right.
It was not.
Okay, so there is no
This
motion
is,
to amend.
this is a court for an order modifying the conditions of a sentence. Maybe
It-
I pulled up the wrong document. Let me see.
Yes,
Motion-
that is correct, Your Honor.
So there, let me see, motion to modify sentence conditions.
Yes, Your Honor, and the state has already stated that they are not objecting to the sentence conditions being amended.
All right, so I'm just looking at the motion to modify. Okay, so this is not, so Ms. McLeod,
Yes,
you
Your
have an objection now to the grounds that you are asserting right now that they don't conform to the motion for a new trial. It talks about, okay, so you've identified that all the information was not presented that should have been presented.
Yes, Your
And
Honor.
you're saying the verdict is contrary to the evidence and without evidence to support it. All right, I'll go with that. Point number one. Point number two, the verdict is decidedly and strongly against the weight of the evidence. So all the information was not presented, but what was presented that the defendant believes was not sufficient to convict him beyond a reasonable doubt. Okay. Was not adequately instructed of the pros and cons of a jury trial versus a bench trial.
Yes,
How
Your Honor.
does that argument conform with the motion for a new trial?
Well, I think, Your Honor, it conforms to it because had he known that he was only going to rely on the opinion of one person as opposed to a panel, that his chances of having an acquittal would exponentially increase. We're talking about 6 people.
We're talking about a very specific deficiency on the part of his attorney of record at the time of the trial. How does the current motion, which has never been amended upon production of the transcript, how does that specific deficiency is highlighted in the motion for new trial? I'm simply asking, how is that reflected so that the state is on notice that that is a deficiency they have to address?
Well, Your Honor, the state is always on notice when there is a motion for new trial that the defense is going to raise
Okay.
that
so
issue. if
That
it is-
issue is out. Next one. Witnesses, defendant believes that witnesses were not called who should have been called.
And that is correct, Your Honor.
Right,
And it
so-
was,
I'm going to give you that. The
Yes.
verdict is contrary to the evidence and without evidence to support it. So I'm going to strike his argument of his lack of knowledge of a jury versus a bench trial, since the state was not on notice that that was a deficiency. Otherwise, they would have been adequately prepared. So the only issue right now is all the info was not necessarily presented,
yes, Your Honor.
and witnesses that should have been called were not called.
Yes, Your Honor. The
Okay.
transcript is clear that the court asked defense counsel about witnesses. And he said that there were some, but he would make the decision after the state had presented his case as to whether or not these witnesses should have been called.
Mhm.
And those witnesses were never called.
All right, so you may proceed on the witnesses that you think should have been called.
Yes. Mr. Bennett, were there witnesses that you had identified to your counsel that you felt would be helpful to your case?
Yes, ma'am.
Who were these witnesses?
Vicky Tatum,
And who was he?
she is Sonia's aunt.
Okay.
She has knowledge of an event. Shantae Beck,
Who is Shante Beck?
a friend of Sonia's who she had an altercation with that has an effect showing how Ms. Baker acts.
Okay.
My Miss Rashida Brown, who is a licensed state of Georgia licensed behavior specialist. She's a neighbor. She observed Ms. Baker several times after the, she has comments to make of what her
Mhm.
trained opinion.
To your knowledge, were any of those persons subpoenaed to appear at your trial?
No, Your Honor,
McLeod.
Miss Vicky Tatum was going to come, but she was called that morning by someone and told not to come.
Do you know
Trial.
who called her?
She said it was either Miss Baker or her mother that called and said if she came to trial, she would never see my children again. So that's what I was told. And she'd be willing to.
I'm going to object to the hearsay, Judge, but I mean,
Response, Ms. McLeod?
It is hearsay, Your Honor.
All right, so it's stricken. Objection sustained.
Well, you believe that those three people, had they come to testify at the trial, would have made a difference to your case, correct?
There,
objection, Your Honor, relevance, his opinion on what would have happened.
Ms. McLeod?
Well, I think it's his case. It was his trial, so his opinion is important here.
Objection sustained.
At the time of the trial, did you discuss with your counsel calling those people at the trial?
yes,
And did he instruct you? Did he say that he would not call them? Is that what happened?
he said that when we came to trial, it would only be about August 22nd of 2022, and no other information would be presented. It was an open shut case, is what he said. But when we got to the trial, other information was brought up prior to that and after that, unsubstantiated, that was all accepted. And I feel that prejudiced the distinguished judge from.
What kind of information are you talking about specifically?
They worked to present me in a bad light, making, it's in the transcript.
Okay, are you talking about, were they saying about events that happened between you and Miss Baker prior to this? Or was this correct evidence you're talking about?
Miss Baker made comments of some event that happened after all of this.
So you are talking about her testimony as opposed to something brought in by the state, correct?
That's, yes,
And you are saying that her testimony was allowed without objection from your counsel?
that is correct.
Okay. Thank you, Mr. Bennett. That's it, Your Honor.
Thank you, Ms. McLeod. Mr. Rosenberg?
Yes, Your Honor. Vicky Tatum, was she there the day or the morning of August 28th, 2020?
No,
Okay, so she doesn't know anything about what you were charged with, the case that you were charged with. Is that safe to say?
only what Miss Baker had told her.
Okay, so she didn't see anything that morning, right?
No, that's
Okay.
correct.
What's this other person's name? Shantae Beck? Was she
Yes.
there the morning of August 28th, 2020?
No,
So she didn't see what transpired between you
no,
and, okay. How about Rashida Brown? Was she there the morning of August 28th, 2020?
no,
Okay, so she didn't see what happened between
nope.
you, okay. Your conversations, how many times did you meet with Mr. Gaither prior to trial?
I came once a month for, gosh, a year.
Okay, so at least 12 times?
Yes.
You discussed
Or
the
more.
case, the facts of the case?
Or more. And again, he said that it would just be about August 22nd and what happened, and all these other things were brought up.
Sure. Did you discuss the facts of the case?
Yes,
Did you discuss your rights as a criminal defendant?
we just discussed the case.
Okay. At some point, do you recall him telling you that you had the right to a trial by jury? Surely you recall.
I'm the one that requested a trial by jury from day one when it was arraigned. I asked for a jury trial. I did.
And at some point, you obviously, you had a hearing before the judge, right? Trial before the judge.
Several.
Sure. And you had conversations about that with Mr. Gaither, right?
The can kept getting kicked down the road, and it took a long time to come to trial.
Sure.
And then all of a sudden he said, wait, we can do a bench trial next week. And this is an open shut case. It's your opinion versus Ms. Baker's opinion. There's no evidence against you. It's only going to be about August 22nd. So let's do the.
Let's try this again. I'm going to ask you a question. You can answer yes or no,
I'm
and then
sorry.
explain. That's okay. You just
Forgive me, I'm sorry,
You went
sir.
right into the explanation. That's fine. So the question is, did you and Mr. Gaither discuss not having a jury trial and letting the judge decide?
We did. Yes.
Okay. That's all I have. Thank you.
Right. Any redirect, Ms. McLeod?
Brief one, Yvonne. Mr. Bennett,
Yes, ma'am.
did your counsel give you the impression that having a bench trial would be quicker than having a jury trial?
Yes.
And was that the reason why you agreed to it?
The case has drug along for 2 years, and now it's another year almost. And my good name is important to me, and I do not wish to be falsely accused. And the other information that was brought up by Ms. Baker was used to discredit me, but I was not allowed to bring witnesses that could show that her testimony may be in question because of other issues that have occurred. And those items were not presented. If it was just about August 20th, the prosecution offered a lot of stuff more than the August 20th date and allowed it to be, they went down that road. But my attorney said they didn't tell me that they were going to do this. They should have told me in advance so that we could prepared for that. He was expecting only to talk about I believe it's August 20th, 2022. I believe that was the date. So since other stuff was brought in, he said that, hey, this is not right. And if you're not happy with this, we can request for a new trial. And that's why I did and have gone through this. There's no disrespect to the court, but I don't feel that it was right.
Right.
And
the question that I had asked and you have answered was about speed. You wanted it over, and he told you this would be faster. That is your testimony, correct?
yes, Your Honor. Yes, ma'am.
Okay, nothing further.
All right. Any recross?
No, Your Honor.
All right. Thank you, Mr. Bennett. You may step down.
Thank you, ma'am.
Anything else from the defense?
No, Your Honor.
All right. Mr. Rosenberg?
Just argument, Your Honor.
All right. The state can go first.
So, Your Honor, essentially they've tried to backdoor a, ineffective assistance claim, I guess. And so I'd ask the court not to consider that because, certainly we weren't on notice of that. But regardless, I'm not going to belabor the issue. I think you sat and tried the case, right? So you heard all of the evidence. A motion for new trial on general grounds generally calls upon you to sort of re-examine the evidence, right? Reconsider the testimony and then make a decision afresh, right? Almost to sit as if there had been a jury, a 13th juror. So it's not really an issue of, whether there was sufficient evidence. It really is just sort of you to rethink about the evidence as it existed at that time. There was ample evidence. You heard from victim. She testified he hit her across the head when the children were there, right? Took her phone away. The taking the phone away is absolutely consistent. You could have inferred that, he took the phone because he knew she was going to call the police because he struck her, right? That's a reasonable inference that I think the court probably made. You had her testimony, which was essentially unrebutted that he struck her, right? The court made the determination at sentencing that this was a toxic relationship, right? You heard about other instances between the two of them where he had also struck her, right? Establishing a pattern. There was really no evidence to rebut that. And in fact, she, had to get a third party to call 911, which actually sort of further supports the idea that something unlawful had occurred, right? So I'd ask the court just to really, on a motion for new trial, you can exercise your discretion, but it should be exercised with caution, and it should be invoked only in exceptional cases where the evidence preponderates heavily against the verdict. And that is not this case. This was a case where she had unrebutted testimony from the victim saying this happened. And that's really all there was, right? There's just weren't a lot of people to see it, and that's fine. That sometimes is the case when things happen inside. So I'd ask that you deny the motion for new trial. Do not exercise your discretion in that regard. And that's it.
Thank you. Ms. McLeod?
Your Honor, I would ask court to grant the motion for a new trial. I think one important factor was that my client did not get the opportunity to present impeachment evidence, which could have impeached Ms. Baker to show that she is in the habit of making false police reports. And my client has indicated that he told his attorney more than once that there was a witness who could speak to that. And also that he had a video of her striking him, and none of that was admitted. That witness was not called, and that video was not admitted into evidence at all. So we believe that the fact that he was not allowed to present impeaching evidence is significant, because when a witness takes a stand and is testifying to something that happened when there were no other independent witnesses around, because there was no one around on that morning except my client and Ms. Baker. But he was not allowed to present any impeaching evidence to show that she is in the habit of making up stories. So to me, that is significant enough that he should have a new trial so that he can put all the evidence out there for it to be seen. Nothing further, Your Honor.
All right, thank you. It certainly helps having a transcript, but also the judge who presided over the bench trial. First of all, with regards to the issue of whether Mr. Bennett was adequately informed of his the pros and cons of a jury trial versus a bench trial, that specific objection was not identified in the motion. To bring this argument now without having Mr. Gaither present to testify as to the nature of his conversations. Attorney-client conversations are clearly disclosable where there is a motion for a new trial and the defendant is alleging that he, for want of a better phrase, received insufficient or ineffective assistance of counsel. Mr. Gaither is not here to corroborate the allegations that he was not adequate, that the defendant was not adequately informed. And as I said, that specific objection was not particularized in the motion for a new trial, so that is not to be considered. Now, what Mr. Bennett is asking the court is that in his opinion, in his lay opinion, that there was insufficient evidence to convict him of the offense of battery family violence, and that the evidence presented by the state was not sufficient beyond a reasonable doubt, which is the state's burden. With all due respect, Mr. Bennett, I have no bone in this case. I have absolutely no interest in terms of seeing you convicted, and no interest on making sure the state carries burden of proof. I'm here to make sure that both sides have a due process, that their due process rights are accomplished and provided for. Now, my recollection, and it's also reflected in the transcript, that the defense had an opportunity to present witnesses, and in fact, they did. They presented one Mr. Robert Laborde, and he testified, and his information was not sufficient to overcome the state's presentation of their evidence, which was established beyond a reasonable doubt. Now, your opinion that your attorney should have called other impeachment witnesses, that was a matter that your attorney, in his professional opinion and his opinion of the strategy of handling the trial of your case in representing you, that is a matter that I have to respect. If you believe that was deficient, I need particularized area in the transcript where that failed, and I don't see that. I read the transcript The first time this case came on a motion, where the transcript was, I already read through that. And I still didn't see an area of deficiency. And today, with all due respect to Ms. McLeod's argument, I still don't see the areas of deficiency. You were provided with a trial that you and your attorney announced to the court that's the process you wanted to follow. A bench trial, a trial before a judicial officer where the judge acts not only as to the nature of the evidence that shall be disclosed or not disclosed, or also as the trier of fact. And as the trier of fact, just as a jury, the judge gets to assess the credibility, the veracity, and the demeanor of the witnesses, as well as to determine which evidence will be acceptable as fact and which evidence will not be accepted as fact. And that's my role. As long as I don't have a bias, and as long as I don't have an interest in the outcome of the case, I did my very best to assess the evidence that was presented, both from the state and the defense. And the evidence that I determined to be fair was a conviction for battery family violence based on the incident of August 20th, 2020. Was it the 28th or 20th? It was the 28th, August 28, 2020. There may have been evidence, there was evidence provided of prior infractions between you and your wife at that time. And that was considered, but the only issue I had to decide was whether the state had established beyond a reasonable doubt that there was a violation of the law on August 28, 2020, and the trier of fact found it so. The motion for new trial is denied. I'd like to move on to the motion to modify the sentence. Is there any other conditions of Mr. Bennett's sentence that has yet to be completed?
No, Your Honor, my understanding is that everything is completed.
All right. And I understand that he was to have third-party transfer or supervised contact with the children?
Yes, Your Honor, but it's not really working that well. There is a legitimation action pending. They just have not actually entered a final order in the case yet.
And what is your client seeking in terms of modification?
He is seeking no further violent contact with Ms. Baker in order that he can see the children, because she prefers to do the exchange herself. It's just has not been working for him with other people. There's his sister, there's her brother, and I believe her mother, but none of them seem to be able to get it done because Ms. Baker prefers to interact directly with my client, but he cannot interact directly with her because of the order.
I see. Okay. He cannot oh, I see what you mean. Okay. Yes, Mr. Rosenberg?
Yes, Your Honor. And what I understand the modification to be exactly is that he may contact her for the purposes of arranging visitation with the children.
That's correct.
Right. And we are okay with that. I've spoken with Sonia and she's all right with that.
All right.
I think frankly, there's only maybe a month left on the sentence,
Mhm.
something to that effect. And so far it's been okay.
So if I amend the sentence to no violent contact with the victim, then that would allow him to communicate with her with regards to other matters, like he could call her up out of the blue and ask her how's the weather and whether they'd like to have a picnic together. So that's,
So yes, that's why we're not okay with that.
you're not okay with that.
Just-
Okay, I just want to understand the scope
Right,
of
that's why I
contact.
tried to narrow it. He may contact her for the purpose, right, of making arrangements for visitation with the children.
All right. Ms. McLeod, do you have any objection to me entering an order that the sentence as instituted shall be amended to allow the defendant to have no violent contact with the victim, in this case, Sonia Baker, to the extent of discussions and conversations with regards to contact and exchange of visitation of the minor children?
You're okay with that?
That's okay.
All right.
We have no objection to that, Your Honor.
Okay. I also enter that order. Motion is granted in part. Anything else?
Nothing.
All right. Thank you, Mr. Bennett. That concludes our case.
Thank you, Judge. or maybe excused.
Yes, no, I'm sorry, Mr. Rosenberg.
That's
Yes,
okay.
thank you. Nice to meet you.
Good meeting you. I think we might have met once on Zoom a little while ago.
All right. You're a lot shorter on Zoom.
Yeah, probably.
Okay, thank you. All right, Ms. McLeod, I will see you next week on Zoom.
Yes.
All right, take care. Take care.
Thank you.
Good to see you, Leah. Sorry. Your client's here, Mr. Houston? All right. Hmm. Okay. Who's handling the Jarrett Houston? Okay, Mr. Birch. Ms. Carter, we are going to address position 4 on the calendar. This is State of Georgia versus Jarrett House. Is it Jarrett or Jarrett? Jarrett with a T.
Yes.
Okay. Jarrett Ansley Houston, case number 21 CR 001-670J. This is going to be a plea hearing with regards to the charges brought against Mr. Houston. I believe that we are only going to proceed with the DUI per se. Would that be correct?
Yes.
Okay. And this is from October 14th, 2019. Mr. Houston, for purposes of the plea, you have a right to remain silent about the facts of the case. Anything you say can and will be used against you. You have a right to counsel, and Ms. Leah Abbasi is going to be your attorney of record. We're going to have a plea hearing. May I place you under oath for just the purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Well, I'm going to deem this to be a non-negotiated plea unless you all have come up with an agreement with regards to the time.
Yes, Your Honor. Actually, after reviewing some of the documents in this case, we are able to give Mr. Houston credit for time served for the 72 hours.
All right, then I'm going to deem this to be a negotiated plea.
Yes.
So, Mr. Birch, you may go first.
Thank you, Your Honor. The defense has agreed to plead to count 2 DUI per se. The conditions on that will be 12 months probation, serve 72 hours in confinement, credit for time served, 72 hours in confinement, $600 fine, 240 hours community service, risk reduction course, alcohol drug evaluation, and any required treatment, and 1 victim impact panel. And in exchange for that plea, the state has agreed to merge count 1 DUI less safe, as well as counts 3 and 4 wrong way on a roadway, as well as reckless driving. Does the defense stipulate factual basis, venue, and identification for purposes of the plea?
Yes.
Nothing further from the state, Your Honor.
Thank you. Mr. Houston, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood your attorney's explanations and what's been going on in the courtroom today?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you or inducing you to enter this plea instead of exercising your right to a trial?
No, ma'am.
If you decide to enter this plea, you will be giving up your constitutional right to a trial before a judge or a jury. You will not have the opportunity to confront your accuser, to be able to challenge the evidence brought against you, to present your defense's arguments and mitigating factors if you choose to do so, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And you understand this will be your second DUI lifetime, I understand?
Yes, ma'am.
All right. This can have consequences upon your occupation, any licenses you may have. Your driver's license will definitely be suspended after this, after today. And it could have an impact upon your residency if applicable. It could have an impact upon any open cases that you may have against you. Has your attorney explained these ramifications to you?
Yes, ma'am.
And are you still willing to move forward with this plea freely, willingly, and voluntarily?
Yes, ma'am.
How do you plead to one count of DUI per se from 2019?
Plead guilty, Your Honor.
All right. Your sentence is going to be 12 months to be served 3 days, credit for time served 3 days. You will report to the Fulton County Probation next Tuesday before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta.
All right.
When you report to probation, you'll be required to pay a $600 fine. You'll be required to do 240 hours of community service. You must do a minimum of 20 hours per month and every month thereafter.
Yes, ma'am.
So towards the last month, if you do a minimum of 20 hours, by the last month, you'll have more than 20 hours to complete in order to complete 240 hours. Do you understand?
Yes, ma'am.
Any questions about that, Ms. Abbasi?
No, Your Honor.
Okay. You will need to complete a risk reduction program, an alcohol and drug evaluation, which you must undertake within 30 days from today.
Yes, ma'am.
You will attend one victim impact panel.
He's done that.
He's done it? Okay. Go ahead and indicate done. Mr. Birch, do you agree?
Yes, Your Honor.
Okay. Counts 1, 3, and 4 will merge into the DUI per se, so the only conviction today will be for DUI per se. And it's your second DUI, so you'll be required to report every month.
Yes, ma'am.
All right. Any questions, Ms. Abbasi?
Your Honor, will he be able to do report via phone or will he have to go in person?
Well, you need to explain to me why it's going to be via phone. Is he also live in Wyoming?
Well, no, he doesn't live in
Okay.
Wyoming.
All right. I couldn't be that lucky one morning. Okay.
Is misdemeanor probation though able to make that determination with their office? If he can phone in or he has to report?
He has to report in.
Okay,
It's not, probation doesn't make that call.
okay, okay.
Anything else?
In person. That's all, Your Honor.
All right. He hasn't completed any of the other requirements, right?
Correct, not yet.
Okay. So, yeah, I think you have to fill out the probation form.
He did?
His report date will be next Tuesday before 3 p.m.
Okay.
and they'll take it from there.
Thank
All
you, Your
right.
Honor.
Best of luck, sir. Thank you for being here, Mr. Oski.
Appreciate it.
All good.
I think that concludes our cases for this morning. Thank you, everyone. Ms. Carter and everyone on Zoom, we are concluded. Mr. Glanville? Thank you very much. All right, y'all take care. Thank you. Bye-bye.